Good afternoon, everybody. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you so much for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Malaysian Citizenship, How the Federal Court in CTEB and CCH Has Changed Citizenship Rights. My name is Carolyn Ng. I'm an associate with Wong and Associates, and I'll be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Wong and Associates is a mid-sized law firm that was founded in 1985 by Datuk Mah Wing Kwai. Our able team today comprises of 29 lawyers and a support team of 30. Datuk Mah is today a consultant with the firm, following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, which includes litigation, adjudication, and arbitration, a dedicated employment/industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our NWK online talk series. By way of background, we have actually been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event that you require specific legal advice on your matter, please contact us for a complimentary legal consultation. Details of that will be given at the end of this talk. Our speakers for today are Jasmine Wong and Eric Do. Allow me to introduce the both of them. Jasmine is a senior associate in our dispute resolution, employment law, and industrial relations, and individuals and families departments. Her areas of practice include citizenship, adoption, medical malpractice, and negligence, as well as employment law. She regularly advises clients on citizenship issues and represents clients in obtaining declarations of citizenships in court. She was the co-counsel in the 2018 and 2021 Federal Court Appeals on stateless and adopted children. As for Mr. Eric, he is a senior associate in our dispute resolution and individual and families departments. His practice areas primarily comprise of family citizenship, adoption, land, and strata disputes. Similarly, regularly advises clients on various citizenship issues and represents clients in obtaining declarations of citizenships in court. And he was also involved in the 2018 and 2021 Federal Court Appeals. We will also be having a Q&A session at the end of this talk, so please post them in the Q&A chat box at the bottom of your screen. The top points for today include the right of citizenship in Malaysia, the federal court decisions in CTEB and CCH, the impact of these federal court decisions, and the court's current approach to citizenship issues. I will now be passing the floor over to Eric.
Thanks, Carolyn. A very good afternoon to everyone. Hope you're having a good day. It's sunny where I am. Hope it's not raining where you are. So, citizenship, and specifically the right to citizenship in Malaysia. Citizenship has been a very hot topic over the past year, and even recently, due to the upcoming elections, parties have been talking about giving citizenship rights to people born overseas. So let's unpack a bit of that. So recently, over the past year, there's been two important federal court cases talking about citizenship in Malaysia. So what are the impact of those cases? Or actually, what did those cases actually say? So today, I'll be talking about briefly the right to citizenship in Malaysia, and also what happened in the cases of CTEB and CCH. And my colleague Jasmine will be talking about the impact of those decisions and roughly what the courts are doing right now after the decisions of the federal court that has been made over the past year. All right, so right to citizenship in Malaysia. Broadly speaking, there are probably around four ways you can get citizenship, Malaysian citizenship. Firstly, by operation of law, which is what we will be talking about mainly today. So this is an automatic right. Once you have satisfied certain requirements, you will get citizenship by operation of law. We also have others like registration, naturalization. These are the naturalizations, like, see those footballers, sometimes they get citizenship by naturalization, and citizenship by incorporation of territory, which I think so far has not been used. So briefly, just wanted to talk about citizenship by registration and how it differs mainly by operation of law. So as I mentioned, citizenship by operation of law is automatic or almost automatic. However, if you try to get citizenship by registration, which these are in Articles 15 to 18 of the Federal Constitution, you will need to wait, basically, because there is a long processing period. It's usually arbitrary, and there is no transparency as to how the decision-making process is done. If you are rejected, you don't know why, and there is a sole and unreviewable discretion lies with the Minister of Home Affairs if you try to get citizenship by registration. It is, however, not an alternative remedy to citizenship by operation of law, so which basically means that if you want to go to court to apply for citizenship by operation of law under Article 14, you can still, at the same time, apply for citizenship by registration. So you can go to the court, you can go to JPN, you can apply for citizenship both ways and see which method will get you the better results or the quicker result. So this is the basic difference between operation of law and registration. Okay, so citizenship by operation of law. What do we have under Article 14, read with Part 2 of the second schedule? So broadly speaking, there are about five sections or 5 paragraphs in Part 2 of the second schedule, which talks about citizenship by operation of law. This is for people who are born after Malaysia Day. Of course, there are a bit of a different sections that apply for people that are born before Malaysia Day, but today we are talking about people who are born after Malaysia Day. And within that, you are split to 2 sections. If you're born within Malaysia or you're born outside of Malaysia. So if you're born within Malaysia, there are 2 paragraphs in the second schedule that applies to you. Firstly, Section 1A, which is that one of your parents is a Malaysian or PR at the time of your birth. So if you're born in Malaysia, one of your parents is a Malaysian or a permanent resident, then you will be a Malaysian at birth by operation of law. I think that is what a lot of people, at least most of the people who are born in Malaysia, will satisfy this. Secondly is Section 1E. This is if you're born in Malaysia, but you're not born a citizen of another country. So this is still something that I think the federal court has not yet decided on how broad this would be, because there are still very cases that says that, if you are, even if you're born in Malaysia and you did not get the citizenship of another country, some courts will say that, you need to show that you have not gotten citizenship of another country, or even you are not eligible for citizenship of another country. So this section is still a bit up in the air, but I think, so this sometimes it depends on the judge and how he or she thinks this section should apply. All right, so these are for people who were born in Malaysia. How about born outside of Malaysia? You have 3 sections. The ones that are in the news is 1B, which is if you're born outside Malaysia and if your father is at time of your birth a citizen and your father was born in Malaysia. This section seems to preclude mothers who give birth to their child overseas or Malaysian mothers from granting citizenship to their children. Of course, this is something that is in the courts at the moment. And we have one case as well in upcoming federal court. So something that is still being debated, whether does this mean only fathers or can a Malaysian mother grant citizenship as well? So B and C is almost the same in terms of the requirement of you having to being born to a Malaysian father. And of course, we have section 1D, which is being born in Singapore. So this is specifically just for Singapore. So if you're born in Singapore and you have parents, one at least, which is a citizen at the time of your birth, then can also get citizenship by operation of law under Article 14. So that is briefly what the laws in Malaysia about citizenship talk about. Now I'll zoom into the cases that we mentioned earlier, which is CTEB and CCH, and I'll start with CTEB. A brief facts about CTEB: in that case, child was born in Philippines in 2010, before the parents were married. Malaysian father, Filipino mother. So then you would be thinking, okay, if you look at the provisions earlier, come back here. So born outside Federation, so Philippines, and father is a Malaysian at the time of birth. So what is wrong? Why couldn't, so definitely this child will be Malaysian, right? According to section 1B. However, there is a quirk in the situation whereby the child was born before the parents married. And then the parents registered their marriage 5 months later after the child's birth. And of course, in this case, also the child also had a Philippines passport. We went to the court to apply for citizenship for the child. At the High Court, application was dismissed. Court of Appeal upheld the decision of the High Court. At the Federal Court actually dismissed the appeal, which means they did not grant citizenship to the child. However, this is a bit of a unique situation whereby it was actually quite a tight decision. It was 4-3, meaning 4 judges were in favor of dismissing the appeal or not granting the child citizenship, and 3 other judges had felt that there are grounds to grant citizenship to the child. And indeed, they each actually wrote a separate judgment, dissenting judgment, to give their reasons on why they think that the child is entitled to citizenship. So this is actually quite rare to see. It's like seeing maybe a shooting star or something. It's quite rare to see 4-3, and I think even rarer to have 3 separate dissenting judgments by the federal court. So what were the issues? Of course, the argument was that the parents, so who are the parents of this child? Basically, the issue turned on the marriage and whether the person was legally married. So in this case, this is an extract from the majority judgment. So the majority said that, look, based on the operation of section 17 of the second schedule, which I will go to later, the word parents in the context of part 3, which is where the section the giving citizenship are, must be construed to refer to lawful parents in a recognized marriage. So this means, what the majority held was, this means that the word parents must always refer to legally wedded parents and not biological father and mother. So if you look at the court, basically said, yes, even though you were born to a Malaysian father, it does not matter, because what we're looking at is what our parents refers to legally wedded parents and not just biological father and mother. So this is section 17 of the Federal Constitution, of section part 3, second schedule, section 17. So what it says is, for the purposes of citizenship, any references to an illegitimate person's father or parent will be construed as references to his mother. Hence, in this situation, in this case, Section 1B couldn't apply because the word father has been replaced as mother. So it means, basically it meant that the child citizenship would follow the parent, the mother, who is a Filipino. And also helped after looking at various cases in Malaysia that citizenship is determined at birth, citizenship by operation of law is determined at birth, and other laws which retrospectively qualify a person, such as the Legitimacy Act or Adoption Act, cannot be used to construe the qualification, which in English means that even though if you are legitimized after your birth, so because the parents of the child got married under the Legitimacy Act, the child would be rendered legitimate. However, it does not matter. What matters was what was the status of the child at the time of the birth, which is a legal term, or in the Malaysian legal terms, is a legitimate child because it was born outside marriage. So it doesn't matter what happened later. What matters is what your status was at the time of birth. And I've shown in this screen, said subsequent marriage of the parents will not change the birth status of the child as a legitimate child. There is no mention made for the rights of citizenship in the Legitimacy Act, and no corresponding provision in the FC, Federal Constitution, that deems legitimation confers citizenship, right to citizenship. So clearly stated here, it does not matter what happens after, it matters what your status is when you were born. Now we come to the minority judgments. So we have 3 minority judgments, as I mentioned earlier. One of it was by the Chief Justice, where Her Lordship basically said that father is biological father. How else can you look at it? Father should be biological father, especially when paternity is known and the said biological father is a citizen of Malaysia. So in Her Lordship's opinion, it doesn't matter whether her parents were legally wedded or not. What Section 1B says is father should be biological father. So your legitimacy status is irrelevant. Second minority judgment by Justice Nalini, who basically said mostly the same thing, in effect, mostly the same thing. And importantly, Her Lordship held, it does not envisage, Section 17 does not envisage depriving a child of a Malaysian father on the grounds of the lack of a legally recognized marriage. So similarly, whether the Her Lordship held, whether the parents were married or not, shouldn't matter. Again, Justice Mary Lim said the same thing. In my view, that the fact that the first appellant's father, the child's father, was not married to his mother at the time of birth does not diminish his right to acquire citizenship by operation of law. The second appellant remains the father of the first appellant, and the legal relationship between the father and the mother of the first appellant does not alter the status of the first appellant. So we have, I would say, pretty strong dissents by 3 judges saying that it does not matter whether a person's parents were married or not. What matters is really what are the ties between the child and, in this case, the father. If the father is a Malaysian, the child should be granted Malaysian citizenship. So that's CTEB. Now we come to CCH. What happened in CCH? So CCH, in that case, the child was born in HUKM. The biological parents of the child were unknown, and the child was handed over to a Malaysian government for adoption. When they applied for my card for the child was called in for investigation, and then it turned out there were some issues regarding who were the actual parents of the child, and then the original birth certificate had to be surrendered to JPN and cancelled because the adoptive parents were not the actual parents of the child. So after adoption was done, we filed a judicial review to challenge the decision of the JPN to not grant citizenship. The Court of Appeal, the High Court did not agree. Court of Appeal also dismissed the appeal, and we had to go to the Federal Court. And what the Federal Court basically said, to allude to the conclusion, Federal Court basically said that a child who was abandoned at birth with no knowledge of his or her biological parents should be a Malaysian or is a Malaysian by operation of law. And this is through the operation of Section 19B of the second schedule, which I will explain to you now. So what does Section 19B say? So Section 19B says, basically, well, long story short, if a person or a child, a newborn child, is born and found exposed in any place, the child shall be presumed to be born there of a mother permanently resident there. For example, if a newborn child was born in HKL, and then the child would, and if you have no idea who the mother is or the parents are, then the child would be deemed to be born there of a mother permanently resident in KL. HKL is in KL. So in the course of discussion on citizenship and the rights of a child to citizenship, the Federal Court made a few findings. Firstly, the court held that citizenship is a concept that is linked to the right to life and personal liberty. So as such, any provisions on citizenship should be or must be construed as widely as possible. Because it's such an important right, the Federal Court found that it's such an important right that it must be construed as widely as possible. So by saying that it must be construed as widely as possible, the Federal Court construed 19B and said that, look, so what do you mean found exposed? Any newborn child found exposed in any place, what does that mean? So the Federal Court held that this includes newborn children who are left in abandoned, numb sites, baby hatches, public toilets, school toilets, places of worship, and so on. So there are possibilities of other places being held to be sufficient for the purposes of being abandoned. And the Federal Court said a literal meaning of exposed suggests a newborn child was discovered exposed at any of these locations. So any child was born abandoned in baby hatch, toilet would be deemed to be found exposed. So once Section 19B is invoked, so any party, which in this case will be the government, mostly government, challenging any of these presumptions must either show and mainly show that the child was not born of a mother permanently resident there. So if you say that a child was born in or newborn child was found exposed in the church, then the government will have to prove no, the mother was not a PR of where the church is located. This is the effect of the Federal Court. So in conclusion, the court held, so since the child was found abandoned in the location aforementioned, which is in this case hospital, it's presumed that he was born to a mother permanently resident there. And it follows that he's taken to fulfill the requirements of Section 1A, as he, having been born in HQKM, was born within the Federation, and his mother is presumed to be PR in the Federation. So applying 19B to Section 1A means that the child satisfies Section 1A and the child should get citizenship. And the Federal Court also said that this case is a precedent on how the Ministry of Home Affairs and JPN ought to deal with all such future cases where abandoned newborn children are involved. So the Federal Court said, look, the burden is on the respondent in this case, the government, to undertake proper investigations to determine the status of the child or the child's biological parents. And if after investigation, it is found that the abandonment is true, then they have no other way, but they must grant citizenship for operation of law. So if you cannot prove that the child is not abandoned, then you must give citizenship by operation of law. Well, that's what we think that the Federal Court said. And of course, the Federal Court also noted that the Ministry of Home Affairs has all the powers, all the people, all the required machinery to conduct the investigations. And in this case, the fact that they could not eventually determine the identity of the biological parent or even adduce any evidence of the lineage of the child indicates that they have not discharged their legal burden to rebut the presumption that the child's mother is a PR in that area. So the Federal Court basically said, like, look, this is a high burden and you have all the power to make your investigations, so do the investigations. And if you cannot, then look, too bad. Then you have to grant citizenship to the child because you cannot prove otherwise. Once we have shown that the child is abandoned, then you have the burden, the government has the burden to show that the child was not. And in CCH, the government failed to do so. So I have talked a bit about CTEB and CCH, and now I will pass the floor to my colleague Jasmine to talk further about the impact of these decisions on citizenship rights in Malaysia. Over to you, Jasmine.
Thank you very much, Eric. Hi, everyone. Good afternoon. Okay, now I will be addressing the impact of the Federal Court decision because as we have seen in both matters, the Federal Court has given quite a lengthy explanation and decision in these two cases concerning the children's right to citizenship. Now, in the first case of CTEB, it appears that the right to citizenship is restricted and the decision does amount to discrimination because on one hand, we have children would be Malaysian citizens if they are born to Malaysian mothers and foreigner fathers. But if you flip the coin around, the same right is not given to Malaysian fathers. The decision in CTEB shows that if Malaysian fathers were to have children born out of wedlock, their children will not be able to take after their Malaysian citizenship. So that appears to restrict citizenship rights for the children. And in the second case in CH, that decision seems to broaden the citizenship rights for the children. We have also seen how the Federal Court plays in protecting the rights of the children. They place the responsibility on the government, namely the Home Affairs and the Jabatan Pendaftaran Negara, to identify the biological parents for these children who were abandoned at birth. So now let us take a look at how the courts have approached these two cases. Okay, you will notice that this scenario is actually rather similar in most of the cases for children born out of wedlock. Cases affected by CTEB would be where the child is actually born when the parents are not legally married to each other, and whereby the father is a Malaysian citizen and the mother is a foreigner, essentially a non-citizen. So in this case of RMN against Ketua Pendaftaran Malaysia, this concerns the plaintiff who is now an adult child, 24-year-old individual who was born in Sarawak. His father is a Malaysian citizen, no doubt about it, and his mother is an Indonesian citizen who has subsequently gotten permanent residence, but that is not a factor in this case. The parents registered their marriage 12 days after the plaintiff was born. So we have the DNA results. It was produced to the court and shown that there is the blood relation between this child and the Malaysian father. So what the plaintiff did was he filed a suit in the High Court and sought to be declared a citizen on the basis that he was born in Malaysia and that he has a Malaysian father. So what the court decided, of course, in opposing the plaintiff's application in court, the government tried to rely on CTEB and argue that the plaintiff should not be that a Malaysian citizen because the parents were not married when he was born. But what the High Court did in protecting his interests is the High Court say, look, I am not following CTEB because in CTEB, the child was born outside of Malaysia in Philippines. But here in this case, we have evidence, it's also stated on the birth certificate that the plaintiff, the child, was born in Malaysia. The court distinguished the facts on the grounds of the place of birth and declared the plaintiff as a Malaysian citizen by operation of law. So it was all the plaintiff, the child, he got his IC 3 months later. And this was beginning of this year, 2022. And this is another case where we see the court take a different position concerning children born in Malaysia to Malaysian fathers as well. This is an appeal concerning 3 matters heard together, but the facts are similar between all of the Malaysian father and a foreigner mother. And at the time of the children's birth, the parents were not married to one another. No doubt the parents registered their marriage after that, but as Eric has mentioned earlier, the court will look at the time of birth, whether or not the parents were actually married when the child was born. So in this case, the Court of Appeal unfortunately relied on the decision in CTEB, and they took a rather narrow definition of the word parents. The Court of Appeal held that the word parents must refer to a father and mother who are in a validly registered marriage. So it doesn't matter whether or not there is the DNA test results to prove the blood relationship between the Malaysian father and the children. What matters is, according to the court, is whether or not the parents were married when the child was born. And as it is, when all these children were born, the Malaysian father was not yet married, was not yet legally married at the time. So unfortunately, it was held that the Malaysian father could not pass down his Malaysian citizenship to their children. This matter is currently pending in the federal court, pending for leave application, another appeal. So we will have to see what is being decided next by the federal court. And this is another case concerning illegitimate children as well. This results in a positive decision for the child, fortunately. This is a 16-year-old girl who was born in Perak. Similarly as well, she has a Malaysian father and a Filipino mother. When she was born, the parents were not married. They only registered their marriage sometime about 14 months after her birth. Same thing as well, she sought to be declared a citizen on the basis that she was born in Malaysia and she has a Malaysian father. A DNA test result was also given to the court to support her contention. So what the High Court found is that because the parents got married subsequently, the child can no longer be considered as an illegitimate person. If the child is no longer an illegitimate person, that would mean the Malaysian father would be able to pass down his citizenship to the girl. And this is exactly what happened here. The girl succeeded in the High Court and she was declared a citizen. The government was not happy with the decision, so they appealed to the Court of Appeal. Court of Appeal agreed with the High Court's decision. So once again, they say that, look, this girl is a Malaysian citizen. The government tried another level to appeal against that decision. But recently, on the 27th of October, the federal court dismissed their leave application. So we have here two different cases, two different approaches taken by the court concerning illegitimate children. One is where they would take a narrower approach, which would result in these children not being able to be declared as Malaysian citizens, even though they have a Malaysian father. And the other approach, which is a more liberal one, is where the father's marital status is not a factor and they are able to pass down citizenship to their children. Now, that was on the case of CTEB because that impacts children who were born out of wedlock. Moving on to children who were born in Malaysia and without knowing the identity of their parents. Now, on the face value of it, based on CH, the second case which Eric has explained earlier, the child would be entitled to automatic citizenship if it is shown that the child was abandoned and nobody is able to show or tell who the identity of their biological parents. And if it was anybody, it would be on the Ministry of Home Affairs and the Jabatan Pendaftaran Negara to undertake proper investigation to determine the identity of these children's biological parents. Now, as a result of CH decision, which was given in November 2021 last year, we have noticed a shift in the JPN's approach. They do not readily accept at face value that a child was abandoned. So meaning to say, just because the guardian or the adoptive parents of these children claim that this child was abandoned, doesn't necessarily mean that the child will automatically be declared a citizen and get my kid or my card. Instead, what JPN has done is they have sought to investigate and take a closer look into each and every case. So that would mean parents would be called in for investigation at least once. We have seen parents being called in twice, thrice, just for the JPN officers to understand and investigate how exactly the child was abandoned at birth. So what about the court's approach? Now, in this case, in MYK against, the child was also similarly to CCH, the child was born in a hospital in Kuala Lumpur. There is no information on the identity of the biological parents. What happened was after the child was born, she was handed over to the plaintiff in this case, a single mother, so that she can raise the child and adopt the child as her own. But because the identity of the biological parents are unknown, JPN has recorded the child's status as a bukan warga negara on her birth certificate. So what the plaintiff did was to file suit in the High Court and get a declaration that the girl is a Malaysian citizen by virtue of CH decision. The government, in opposing the plaintiff's, the mother's application in court, they tendered evidence whereby they have the doctor's letter disputing that the child was actually in the hospital in Kuala Lumpur. So essentially what they claim is that we do not know where the child is born, but the child is not born in this hospital in Kuala Lumpur. That's about it. But what the court did was, this is what the court said. The judge took note and recognize that there are suspicious evidence as to whether or not the child was indeed born in this particular hospital in Kuala Lumpur. But regardless of this fact, the fact that it is the place of birth is being disputed, the court relied on CH and protected the child's interest and right to citizenship. And on that basis, the court also took note the fact that the biological parents are not known. There is no evidence whatsoever that could actually tell who the mother and father are. And by virtue of CH, the court in October 2022 declared this girl as a Malaysian citizen, or on the basis of 19B that we have seen earlier. In another case, similar facts as well for LWP. These are the adoptive parents of a child who was born in Selangor. And same thing as well, we do not know who the biological parents are. LWP have, together with his wife, has adopted this child as their own kid. Because they do not know who the biological parents are, JPN also similarly registered the child status, the child citizenship status, as a bukan warga negara. The suit was filed in the High Court, and they tried to get a declaration for the child on the basis that the child was abandoned at birth, without having any information whatsoever on the identity of the biological parents. The second ground was that the child was also a Malaysian citizen because the child was born in Malaysia, and the child having the plaintiff, both who are which Malaysian citizens. Once again as well, because of CH decision, the government took an opposing position and disputed, and they denied that the child was abandoned. So arguments were put forth in court as to whether or not the child was in fact really abandoned, and whether or not the identity of the biological parents could be identified. The fact is that throughout the proceedings, biological parents were unknown. Nobody could tell who they are. But what happened was, because of the reliance on this abandonment argument, the High Court actually took a closer look as to how the parents claimed that the child was abandoned. Because there was insufficient evidence to show that he was abandoned, the child was abandoned, the court rejected this. The court said that I'm not too convinced that the child was abandoned. On this basis, I cannot declare the child a citizen on the abandonment argument. But what the High Court did, once again, in preventing the child from being stateless, the High Court found the fact, put the position, decided that because the child was born in Malaysia, and there is no doubt about it, it is not disputed that the child was born in Malaysia, the child can be declared under a different provision, under the place of birth argument. The point that I'm trying to put forward in this case is that courts will be taking a closer look on how the child is abandoned. And if there is insufficient evidence of the abandonment, or if the High Court is not convinced, then it is very likely that the court will not declare the child a citizen in Malaysia. But there are other provisions which the court may also rely on, such as the child's place of birth. So that will be end of it. And I think we may have some questions from the audience. Carolyn, over to you.
Yeah, so if anyone has any questions, you can just post it in the Q&A box or the chat box, and then we will address them from there.
This is actually a rather heavy topic for anybody to understand, but I do not see that we have any questions here.
Oh, okay. We have one Q&A. Okay, so the question is, if the child is a non-citizen and subsequently Malaysian parents adopt the child, would the child be a Malaysian citizen?
Not automatic. The cases that we have, the authorities that we have are quite clear on the basis that even though Malaysian parents adopt a child, it does not automatically grant citizenship to the child. And that is exactly how the courts have taken that position. Because also another point to look into is that our Adoption Act doesn't provide for this kind of situation. If you want to compare to other countries, some of the countries, they have said that if Malaysian parents adopt the child, then that citizenship would be automatically afforded to the child, but not in this case. So short answer is no, not automatically. So that's why parents would still have to go to court and try to get declaration of citizenship on other.
Thank you, Jasmine. Our next question here is, may I ask, what are the examples of evidence that can be used to show that the child is abandoned? Eric?
Evidence. That is a very fact-specific thing. Sometimes, I think clear examples of a child being abandoned is if you find a child in a baby hatch. I think that is quite clear that the child is abandoned. Of course, these are newborn children. I think it is disputed whether if you find a 1 or 2-year-old kid abandoned aside a road, will that still fall under the CH kind of decision? But if you're talking about newborn, like really like maybe a few days or first week, if you find baby hatches, or sometimes you will read stories of people saying, oh, I heard a child crying in the toilet and then I got the child. So no, I think that would be sufficient to show that the child is an abandoned child and found exposed in the place, and that will satisfy CH tests.
Can I also just add to say that in cases where, we have always read in the newspapers where the child was left and dumped by the roadside or in mosque, in the school, in toilet. In such cases where you have supporting documents such as police report, and if that incident was actually reported in the newspaper, which actually happened in one of our clients' case, the government wouldn't take a strong approach to oppose that case. So they would likely accept the evidence because we have all the police report, the newspapers report to show that the child was just left there. They would likely grant citizenship to the child.
I see. Thank you. Thank you, Jasmine and Eric. Our next question is, do you think that this will open more doors for stateless children and adults to finally be able to live a normal life?
I would say it definitely is. It definitely shines a light on a darker situation before this, because previously we do not have any cases which would be in favor of these stateless individuals. But we definitely are seeing a different outcome moving forward. It is still not going to be easy as we think it is, but the percentage, the chances of helping these individuals is definitely higher.
Thank you, Jasmine. Our next question, is there a reason that the government appears to regularly oppose citizenship cases? Right? Over to you.
Wow, this is a very hard question. All policy decisions, and it really depends on the government of the day, and only they really know why they oppose citizenship cases, especially when the facts are clear that either a child is abandoned or other reasons, or like the child is born in Malaysia and have not obtained any other citizenship of another country and the parents are unknown. So really, to me at least, I really don't understand as well why they want to oppose. That you have to ask the minister. I would say maybe you can, now that it's election season, maybe they can answer that.
We do have some ministers who claim that citizenship matters are national security. It concerns national security. How and why, we do not know.
Yeah.
Thank you, Eric. We have our next question here. What if the child was born out of wedlock by a Malaysian biological father? Sorry, I think there are a few more facts here. The mother is Indonesian, born in Hospital University Malaya, and the child has a birth certificate that is issued by JBN.
Sorry, what's the question?
It just says, what if the child was born out of wedlock by a Malaysian biological father?
That is the exact situation which we have been discussing in CTEB, because that concerns, all of the cases concern biological Malaysian father. So if you put a logical understanding of it, it shouldn't have prevented the child from getting citizenship because the biological father is a Malaysian. But unfortunately, that is not the case. So arguments would still have to be put forth and we'll see how that goes, because as it is now, we have already seen two different kinds of decision for this kind of situation.
Thank you, Jasmine. We have another attendee asking, has the government applied for review of the FC's decision in the CH case broadening citizenship rights?
Not that we know of. I don't think they will, because now they have seemed to, as I think Jasmine has explained, they have changed their strategy in the sense that they're saying, okay, you're saying that CCH says abandoned child can get citizenship. Okay, then you prove that the child was abandoned. So that seems to be what strategy they're taking. That, okay, you prove abandonment, then we'll talk further.
I believe this is our final question for today. Currently, the government is disputing the rights of the child born to a Malaysian mother to be declared a citizen. What, in your opinion, is the rationale of the government on this opposition?
I wouldn't want to comment too much on this issue because we are actually one of the instructing solicitors and counsel for this case as well. This matter is currently fixed for coming up for hearing in the federal court on 14th of December. But like I said on the rationale earlier, the government has always taken the position that this is a sensitive issue, one where concerns the national security. So really can't exactly tell why are they taking such a hard position on this.
Just one thing to note again, seems that a lot of the political parties recently saying that, oh yeah, after the election, we will be changing the laws and will be granting rights to Malaysian mothers who give birth to children overseas to pass down their Malaysian citizenship. So yet to be seen whether it will be imposed, but seems to be a good development. But of course, the court case will still go on until we hear otherwise and until the law has been changed.
Thank you so much, Jasmine and Eric, for your insights. Before we conclude for today, I just have a few more announcements to make. First of all, please join us again for our upcoming talk. Our next talk is actually on the 30th of November. It is on company directors and their fiduciary duties. You can also scan the QR code on the screen to sign up for our online talk. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. Thirdly, do follow and like our social media accounts. We're on YouTube, Twitter, Instagram, LinkedIn, and Facebook. And fourthly, if you would like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link is posted in the chat box as well, or you can scan the QR code on the screen. To all of our guests, thank you so much for joining us. We hope that you have found today's session to be informative and useful. And we hope to see you at our next talk. Thank you so much.